Thank you so much for joining us today during your lunch hour. We're looking forward to an introductory conversation about estate planning with John Davis. My name is Mira Wonderwheel. I'm Oregon Tech's annual giving manager. And one of my roles is that I have the wonderful opportunity of meeting with people who have decided to include Oregon Tech in their own estate plans. And these types of gifts truly do leave a lasting legacy that is in alignment with your own personal passion. First, I'd like to acknowledge my colleague, Becky Burkeen, Alumni Relations Manager, who has really led the preparations for this Lunch and Learn opportunity. And she's also providing tech support behind the scenes. So thank you very much, Becky. I do want to mention that we had originally planned to have Jean Christian do this presentation today. And unfortunately, sadly, Jean is dealing with some health issues personally, and he is unable to be here. So please do join us in holding Jean Christian in your own thoughts and prayers. Before we get started, just a little bit about our Zoom process here. We do sincerely apologize if we do have any technical difficulties, but please do be rest assured that we are recording this presentation and it will be available afterwards in case there are any technical difficulties via Zoom. We're excited to have so many of you with us today. You are welcome to turn on your camera using the little camera icon at the bottom of your Zoom box. And we do ask that for the presentation portion, you use the mic, you do mute yourself, and that's found with the little microphone icon at the bottom of the Zoom box. You are welcome and encouraged to use the chat feature throughout the presentation. You can ask questions and I will be monitoring those questions. If they get answered throughout the course of the talk, then we won't include them in the Q&A, but if they do not seem to get answered, then I will ask them during the Q&A session. A little Zoom tip that I have learned is that you can right-click on the video of the presenter, for example, and pin that person's video so that you will always be able to see it. And that's kind of useful for a presentation type of Zoom event like we're doing today. So now, without further ado, I would like to introduce our speaker, John Davis, who has agreed to step in and share his expertise with us today. John Davis is a business, nonprofit, and estate planning attorney with Lynch Conger LLP, with offices in both Bend and Portland. He helps individuals, business owners, and nonprofit organizations reduce risk and plan for the future by creating wills, succession plans, complex family and business trusts, and partnerships. When not in the office, John spends his time with his two sons, William and Charlie, and his wife, Sarah. John is an avid hiker, golfer, reader, and can often be found watching and reading about F1 racing cars and things that go fast. Now, that's something I just learned about John in getting the opportunity to share his bio with you. John graduated first in his law school class at Willamette University and was valedictorian. He previously practiced in Oregon, Portland, Oregon, at McEwen, Gisvold LLP, and Schwab, Williamson, and Wyatt. I have the pleasure of working with John in his role as Vice President of the Oregon Tech Foundation Board of Directors, where he has served as a board member since 2017. John previously served as the state representative for House District 26 in the Oregon Legislature from 2013 to 2017, representing the communities of Wilsonville, Sherwood, Kingwood, Hillsborough, Tigard, Beaverton, and Aloha. In the legislature, John was an integral member of the House Revenue Committee with jurisdiction over Oregon's tax policy and vice chair of the Transportation and Economic Development Committee. John earned his Bachelor of Arts, summa cum laude, from George Fox University, attended the University of Oxford as a visiting student scholar, and graduated from law school at Willamette University, summa cum laude. John, thank you again for agreeing to talk on such short notice. Before we turn it over to you, I know that we have a poll set up to see where people are in their own estate planning journeys. Please go ahead and mark, do you not have a plan yet, knowing that you will create a plan soon. You are in process of creating a plan, you have a plan, or yes, you have a plan, but you're planning to revise it. Looks like most people do not have a plan yet. Some of you are in process, and some of you do have plans. That's fantastic. So let's go ahead and give this just a couple more seconds. All right, so predominantly, most people do not have a plan. So you're never too young to have a plan, and I think, John, I will pass the proverbial microphone to you, and you can kind of keep this in mind as you're going through the conversation.
Great. Well, thank you so much, Mira, and thank you, Rebecca, for setting this up and inviting me to share with you today. I would love to see you so that I'm not just looking at myself. So I know some of you are eating lunch and doing other things, but if you want to turn on your video, it just makes it much more fun, I think, for these Zoom meetings to be able to see each other. So with that, I'm going to talk for about 20, maybe 25 minutes about the estate planning process, and then I'll be open to kind of taking questions. And I love estate planning, and I also love Oregon Tech and charitable estate planning as well. So part of what I'll talk about at the end today is how do you incorporate maybe some charitable wishes into your estate plan in an effective way so that you can take care of both your family, but also have high impact giving for charitable purposes. So I like to start this whole thing about estate planning by talking about the different ways that assets are passed when we pass away. Because I know so often we default to thinking about, well, I need to have a will, and I need to make sure my will is in place. And that is true, but there are actually 4 ways under the law that you can pass assets when you pass away. And most of you already have some planning in place, whether or not you know it. The primary way that's most often used these days is simply joint ownership. So if you're married or you have a child or a parent, for example, that you might have a joint account with, by virtue of the fact that you have a joint bank account, or you own a home together with that person, or you have an investment account with another person owned jointly, that is estate planning. And it's estate planning because when you pass away or when your co-owner passes away, by operation of law, by the fact that you have joint ownership of that asset or that account, a death certificate is presented either to the county or, in the case of a bank or financial institution, to that bank, and then voila, by operation of the law, whoever is the survivor becomes the owner of that account. And so I'm sure everybody or almost everybody on this call has some form of joint ownership. And if you don't have joint ownership, then it takes us to the next level, which is beneficiary designation. Almost all of us here have some form of retirement account, life insurance, whether it's term life insurance or employer life insurance or whole life insurance, a retirement account, a 403b, some form of investment account for retirement or insurance. Those are actually contracts that you have with an insurance company or with an investment company. And part of that contract is to manage your investments and make selections for the stocks, bonds, mutual funds, ETFs that you want to have, or the type of insurance that will be provided. But another part of that contract is the beneficiary designation. And this is really important because your beneficiary designations, because they are a matter of contract, override whatever you put in your will or in your trust or in joint ownership. So beneficiary designations that you have are going to override and control. So much of the time I will meet with clients. They'll come in and we'll have a beautifully designed plan. And you know what? The bulk of their assets are sitting in a retirement account. And I ask, well, what's the beneficiary on this retirement account? And they say, I don't know. I set it up years ago and I haven't looked at my beneficiary designations in 10 years. And you'll put all this work and spend all this money on an estate plan, and people will not take the time to look at their beneficiary designation. So those two pieces are very important to realize, that whether or not you have a will or a trust set up, you already have an estate plan for your joint assets or for your assets that are controlled by a beneficiary designation. And then we get to, well, what happens if it's not a joint asset, or it doesn't have a beneficiary designation, or that beneficiary has maybe passed away? Maybe you name a spouse or a parent as a beneficiary, and that person, when you die, is no longer left. That's when we get to the traditional way of passing assets, which is a will, or used more often these days, a trust. Now, much of what I'm going to share now is contained in the estate planning guide that you should have received in your email today or in a previous day, which is a helpful kind of 20-page guide, which will go over some of the things that we talk about today. Now, I'm not going to go through it point by point, because when I have a document in front of me, what happens is I start reading the document instead of listening to what the presenter is talking about. But you don't have to remember every single thing we talk about today. You can refer to this resource guide, because it will cover many of the things I talk about and more, because it is 20 pages and I'm not going to talk through 20 pages of material today. And then I'll also talk about some of the other resources that have been attached to the email. But the first thing that you'll notice in the resource guide is, what is the estate planning process and what is having a will? So the estate planning process is really you sitting down with your significant other or your family and setting priorities for, number one, who you want to manage your assets when you're no longer able. And there's two aspects of that. Who would you want to manage your assets if you passed away? And who would you want to manage your assets if you became incapacitated or could no longer care for yourself? That's a key question. So who's managing your assets? Who has the checkbook if you are no longer around to write those checks and to make those decisions? So part of the prime priorities with making an estate plan is really, it's all about people. Who is going to be there to care for you and to care for your assets when you're not available and you're not around? Also, part of the process that you would work with, usually with an attorney, is to collect and inventory all the things you own. So I just talked about bank accounts, property that you may own, investment accounts, life insurance, sitting down and inventorying everything you own and making sure that all of those pieces of your estate, all of those assets, are aligned according to your wishes. And then it is taking the plan, the priorities that you've talked about, who you want to manage your assets, and setting priorities for who you want to take care of with those assets after you're gone, spouse, kids, and charity. Gathering all the information, the inventory of assets, the inventory of what you own, your contracts, your life insurance, and then sitting down with a professional and implementing and drafting those plans. That's kind of the process that we go through. Now, I talked about accounts that you have that may be joint titled and joint ownership, and I talked about life insurance and retirement accounts that are controlled by beneficiary designations. Once you and your spouse are gone, or once you have an asset that's not joint ownership, that's when the will comes into play. So most often we're dealing with folks who maybe have a beneficiary designation on their retirement account. Maybe they have even a beneficiary designation or a transfer on death designation on their bank account. But then we get to property. Property is kind of the prime asset that's often controlled either by a will or a trust. And a will, in order to be effective and to transfer assets, has to go through the probate process in Oregon. And the probate process is the process by which whoever you name in your will is the executor. And in Oregon, an executor is called a personal representative, takes your will, takes your death certificate as well, submits it to the court, usually in the county in which you passed away, and then goes through the court-mandated and overseen process of transferring the assets. And that process is rigorous in the sense that the court oversees each part of it with the executor, the personal representative. The court oversees the inventory. You have to provide an inventory of assets to the court and say, this is what the deceased person owns that's not controlled by a beneficiary designation or joint ownership. These are the probate assets. Number two is you have to take steps as the executor or whoever you name as the executor because you're gone, has to go through the process of collecting all the debts and identifying all the creditors, all the debts that are outstanding from the deceased person, and paying those debts. The executor is also required to pay taxes because once we all die in the middle of the year, even if it's on January 1st, we owe taxes for the year in which we died. So the executor has to make sure the final tax return is paid for both the last year, if there hasn't been a return for the previous year filed, and for the year in which you passed away. And then the executor, and we'll talk about this a little bit more later, the executor has to make sure that any estate taxes are paid. And in Oregon, we do have an estate tax, and I'll talk about what that process looks like. And once all those pieces are done, once the will has been submitted, the death certificate has been submitted, all the family and heirs have been notified, all the creditors have been notified, there has to be a publication in a newspaper. Once creditors have been paid, once taxes have been paid, once all of those steps are done, then the court will authorize the executor to make the distribution to the heirs or to they're called devisees. Isn't that a great name under Oregon law? I like to think of them as beneficiaries. That's usually the term we use more often now. The beneficiaries set forth in the will, the court then authorizes the executor to distribute the assets. And so what we want is for all the different tools in your estate plan to work together correctly. What we don't want is for you to have wishes set forth in your will that are different from the beneficiary designations that you have set forth in your retirement account. These days, the primary assets that Americans have are retirement assets, life insurance, and the homes. And guess what? All three of those things are governed by different documents usually when it comes to who the beneficiaries are. The life insurance contract is going to be governed by the beneficiary designation. Your retirement account, your 401k or 403b or IRA are going to be controlled by the beneficiary designation, not by your will. And then all your other assets that don't go through beneficiary designation are typically controlled by your will. Now, is there a way to bypass the probate process? The answer is yes. And the answer there is to use something called a revocable living trust. You may have heard of it called a trust or a revocable living trust or a living trust or a family trust. It goes by different names. But the process with a trust is that you, in advance, you draft a document, a trust document with your attorney that looks a lot like a will. It talks about your family, talks about who you want to be your trustee, which is the word we use in the trust context for an executor, who will manage those assets, collect those assets, pay final debts, and then make the distributions that you have set forth in your trust. So you'll have your family, your trustee, and your beneficiaries all named. And this document, by creating it in advance and then taking steps to place assets in your trust, either by retitling your home and your real estate in the name of the trust, putting your bank accounts and investment accounts in the name of the trust, or aligning your beneficiary designations on your life insurance and your retirement account to flow through the trust. What happens is because the trust is in existence and funded when you're still alive, the moment you become incapacitated or when you die, the trustee, whoever you have named as the successor to you, because you have complete control of your assets when you're alive, but whoever you've named as that trustee, that successor, the day after you pass away or when you become incapacitated, they are empowered under the law to take control of your assets, pay those debtors, and make the distributions to your beneficiaries without having to go through the probate process. And Oregon has a trust code that governs the duties and the responsibilities of the trustee, which are very similar. They're a fiduciary, just like an executor in court. Courts can get involved if there's a trust dispute or if you need to deal with certain creditors. So there is a process that is overseen, if necessary, by a court, although the goal is usually to avoid the 6 to 12-month process that a probate requires by making the administration quicker and less expensive with a trust. So in summary, I know I've been talking for quite some time about the ways you transfer assets, but there's 4 ways when you die. Number 1, joint ownership with somebody else, a spouse, a loved one, a parent, joint ownership. Beneficiary designation, life insurance and retirement accounts primarily, and sometimes investment accounts. A will for your assets that aren't covered by the first two. A will is used, and then a trust if you want to avoid the probate process. And the reality is, even though in my practice I tend to recommend trusts more often because I've had experience probating estates and I have a lot of experience administering trusts with clients, and I find that in nearly every case, my clients, especially surviving spouses, surviving family members, prefer the ease of administration with the trust. The reality is you're going to find some differences as you talk with attorneys and if you meet with an attorney. And as you talk with practitioners, some people just have a preference for the probate process and some people have a preference for a trust. And you can do all the same things with either a will or a trust. You'll often hear, oh, I need to set up a trust for fancy tax planning. And while I do believe it's easier to make some of the tax elections that can be made with a revocable trust, with a living trust, it is still possible to have all the same fanciness and tax planning with a will. In fact, I have some of my largest clients who have some of the largest estates, and they've just said, John, we just prefer to have it overseen by the court. And that's fine. And I've talked to them for years about the differences with a trust or an estate. But you'll find attorneys and you'll find financial advisors and you'll find other people in our industry who have differing views on whether or not a will or a trust is the right thing. Now you think, okay, great. I've got my beneficiary designations lined up. I've got my joint ownership or my ownership of my accounts lined up. I've got my will in place. I've got a trust maybe. I've got everything I need, right? Well, the paper continues. There's other documents that I recommend that everybody have as part of their estate plan. One of those that you're probably familiar with is a power of attorney. And a power of attorney is used to give somebody else, oftentimes a spouse or a loved one, authority to act for you with respect to financial matters, your bank accounts, retirement accounts, etc., if you become incapacitated. That's a key thing to understand. A will or a trust will control when you die. A power of attorney is only effective while you're alive. If I had a nickel for every time I have a new client come to me and said, oh, my parent died, but I've got their power of attorney, or banks see this all the time. People walk in and a loved one has been lost and the successor walks in and said, well, I've got the power of attorney. And as soon as somebody passes away, a power of attorney is no longer effective. So a power of attorney is good while somebody's alive, while they're incapacitated, while they're in surgery, if they're in a care home or a nursing home and can't manage their own finances. The power of attorney is effective to allow somebody else to manage funds. And there's a limited power of attorney or a general power of attorney. So sometimes, and you've probably experienced this, you may have an elderly parent, you may have a loved one who wants to give you access to a bank account, but not all of their assets. And you'll often have banks, they'll have you sign a limited power of attorney, and that gives you access over the single asset that is described in that limited power of attorney. When you come in and do an estate plan with me and with most estate planning practitioners, or if you use LegalZoom or Rocket Lawyer online or something like that, you will almost always get a general, durable power of attorney. And a general power of attorney gives your agent, whoever you name, we often call that person the power of attorney, but technically the legal name is the agent under the power of attorney. You're giving them general authority for all of your assets with that power of attorney. So we think of the will is for after we're gone. The power of attorney is when we're still alive. I also have all my clients sign an advance directive and medical power of attorney, because the general power of attorney typically covers financial matters, but not medical. So Oregon has a form of advance directive and medical power of attorney where you can designate who can control your healthcare decisions if you're no longer able to make those decisions yourself. So number one, it gives somebody else authority for those healthcare decisions. And then number two, it allows you to select your preference for life-sustaining treatment, tube feeding, and end-of-life care if you're in any of those situations where you might be in a coma, where you're unconscious and will live a long time. Do you want to be sustained on life support and tube feeding, or is your personal moral preference to not be kept alive in those situations? And so there's a detailed questionnaire that goes with Oregon's advancce directive and medical power of attorney. So as you're thinking about what are the documents that I might need as part of my estate plan, you're going to want, number one, you're going to want to look at your account ownerships and your beneficiary designations. Be sure to check those. Number two, you're going to want a will or a trust. Number three, you're going to want a financial general durable power of attorney. Number four, you're going to want a medical power of attorney or an advancce directive. You'll often hear that referred to as a living will. Other states call it a living will. Oregon calls it an advancce directive. I call it an advancce directive and medical power of attorney. So we're covering with your medical power of attorney while you're still alive, with your general durable power of attorney, your financial matters while you're still alive, with your will or your trust, you're covering what happens to your assets when you're gone. And then we want to answer the question, what happens to you and your body? You can select ahead of time through the documents, and one of which we've provided to you already in the packet, a disposition of remains and your wishes for where you want to be buried. So you can specify in advance whether you prefer burial or cremation or don't have a preference. You can specify where you want to be laid to rest. And then you can also specify who you designate as the authorized person to take care of your body and your remains. So we're trying to cover in a comprehensive estate plan while you're alive and well, what happens if you become incapacitated, and what happens after you die. And I want to direct you, Rebecca's got pulled up a attachment that you should have received called the My Final Wishes Plan. It's about the largest attachment that was sent to your email. But this includes all the bells and whistles you could ever want when it comes to planning in advance for your burial, your funeral, and the disposition of your body. And this goes in as much detail as you want to get. You don't have to fill all this out. In fact, most of my clients don't fill all this out, but some of them do. You can designate your funeral and your burial arrangements. You can designate whether you prefer organ donation. You can designate the disposition of your body and your remains, as I just talked about. You can designate where you want to be buried, what you want your grave marker to look like, your casket and vault selections, the preparation of your body, the flowers, the music, the obituary information. As much as you would like to designate for your family, you can use. And this is a very helpful document because you can fill this out in advance of meeting with a professional or an attorney. And this will be a really effective document for your family. I just lost my father last year, for example. He passed away at 85 in November, had a wonderful life, wonderful practice as a professor and a psychologist. But my dad could just never make a decision when it came to where some of his stuff was going to go and where his body was going to go. So we knew he wanted to be cremated, so Dad was cremated, and then it took us until August of this year to decide where we were going to bury him because he had a couple options out there. And I, in retrospect, this is what I do, but I would have preferred that my dad just be very clear. It would have been a gift to his family if he had just said, here's where I'm going to be buried, and here's how I want it to look, and maybe here's what I want on my grave marker. Now, people have different perspectives on how much they want to plan ahead for that sort of thing. But if you would like to provide that, I really see it as a gift to your family. And then that gets to what about your tangible personal property? So I've been talking about, the big assets, right? The house and the retirement account and your investment accounts, but you've got your stuff. You've got the things in your household. You have, the jewelry, the family heirlooms. Well, under any well-drafted will or trust, you will have the ability to use a separate document called the Distribution of Tangible Personal Property, which is pulled up on the screen right now. And you can use a document like this to ahead of time designate who you want to receive particular items of personal property. And this is different because you may want, for example, your children or loved ones to receive the bulk of your assets, but you've got cousins, friends, other family members who you want to receive that piece of artwork or, that piece of jewelry, whatever it may be. You can designate specifically without having to go into your will or into your trust and change it every time that you want to make changes to the distribution of personal property. You can use this separate document and make changes to it. I will say that there's myriad of stories even from my own family, losing my dad. One of my sisters just swears that dad told her she could have this watch. My dad was a watch guy, so he had like 10 watches, right? She just swears that dad said, I can have this watch. Well, we can't find the watch. We don't know where it is, right? So there's just constantly one of those nagging things with my family of there's the watch. Gene Christian tells a great story, which is a little bit tragic, right, of his father passing away, and he has two other siblings, and his dad passed away with almost no assets and was left with basically a pickup truck, a gun in the back, a shotgun, a jewelry, and a piece of jewelry, which was a necklace, right, from his wife and from Gene and his siblings' mom. And you know what? There was nothing in Gene's dad's truck that said anything about who gets what. So Gene worked with actually the sheriff's deputy who was there and found his father to get the truck sold, get the tools in the back distributed, get the gun sent off, and then Gene made a decision which of his sisters was going to get the piece of jewelry. And Gene tells the story that to this day, the sister who didn't get the piece of jewelry is mad at Gene for giving it to the other sister, right? So we often think, oh, well, the rest of the family can decide who gets my stuff. But these are the sorts of things that really are a gift to your family if you can decide where you'd like to be buried, how you'd like to be laid to rest, and then what happens with your important personal property, right? The valuable jewelry, the mementos in the family that mean a lot. I really see it as a gift to family. And when it's well laid out and when it's taken care of in advance and go through this process and take this time, it really is a gift to your family. That's what I've seen in my practice. Now, speaking of gifts, the estate planning process is also one of the most powerful ways to make a charitable gift. And it is for a couple of reasons, taxes and because of the impact that it can have. So I mentioned that I would talk about the Oregon estate tax. The Oregon is one of a minority of states now that still has an estate tax. Oregon's estate tax kicks in at all assets that you own of any type, including retirement accounts, life insurance, value of your home, all bank accounts you have and the stuff you have, everything you have, it's aggregated together and added up. And if you're in Oregon, Oregon does the wonderful thing of they actually add up the value of everything you own anywhere in the world. That means even if you have a vacation house or a piece of property in another state, they count that to get to the $1 million exemption. So Oregon taxes everything above $1 million. And again, that's the value of retirement accounts, everything, unless you've used a fancy estate planning technique with an irrevocable trust or you've gifted assets to your family while you're alive, everything is considered included in your estate. So Oregon's estate tax kicks in at $1 million. Some of you may be in Washington. Washington's estate tax kicks in, I believe it's 2.2 million now. It's adjusted for inflation each year. Oregon's is not adjusted for inflation. And everything you own above those exemption levels, and I'll just talk about Oregon, is subject to an estate tax. Oregon's estate tax starts at 10% and ratchets up every $500,000 to a maximum rate of 16%. So if you think about everything added together, if someone had retirement accounts, life insurance payable, the value of their home, et cetera, et cetera, et cetera, all of that added up to say $2 million, you would have $1 million exempt from the estate tax, and you'd have $1 million subject to the estate tax. The estate tax rate would be 10% on that $1 million, and so there'd be a $100,000 estate tax bill. And so that's why I use this as a transition to talk about charitable giving can be one of the most powerful things you do when you pass away. First of all, you've taken care of yourself and probably your family during your life. And this is an opportunity to leave a legacy, whether it's with Oregon Tech or with any other charitable institution. So for the impact it makes, it's tremendous. And I've seen the impact in working with many of my clients who are charities. I work with a lot of charities, with working with Oregon Tech Foundation, of course. So think of number one, the impact that you can have. Number two, the tax benefits. Whatever you give to charity when you pass away is carved off of that estate tax. So let's say you have in Oregon a $2 million estate, you pass away, you give away $1 million to charity and $1 million to family. the $1 million you give to charity is taken off of your estate size, and you have no estate tax due at all, because you only have only the $1 million that's going to family members is subject to the estate tax. So it's a great way to reduce any possible estate tax burden. When it comes to retirement accounts, I'll circle back to kind of one of the things I started talking about. One of the most powerful things you can do is to do charitable giving with your retirement account, because most of our retirement accounts, unless they're a Roth IRA, have not been taxed. It's an IRA, a traditional IRA, it's a 403B, it's a 401k, and those funds have not yet been subject to income tax. And for those of you who experience required minimum distributions, as you take out money from the retirement account, it's subject to income tax. That's not so if you designate a charity as a partial or a full beneficiary of the retirement account. Whatever you designate to charity, you get two tax benefits. One, the charity gets the entire amount tax-free because the charity is income tax exempt. So if you have a $100,000 retirement account, you give $100,000, you give 100% of that to charity. The charity is going to get the full $100,000. They will not take deductions for income tax. So that's benefit number one. Number two, if you name a retirement account to a charity, that's deducted from your gross estate for purposes of calculating the estate tax. So that's why it's like a real double tax benefit. Now, I've got clients who say, well, I really want to make a charitable impact, but, I'm not comfortable giving a huge amount or my entire retirement account or a big chunk of my assets to charity. So are there other vehicles? And you may have heard of things like charitable gift annuities or charitable remainder trusts. I think the charitable remainder trust is one of the coolest high impact estate planning and charitable devices that we have now. So a couple things to preface it. One is that because of a change in federal law on January 1st of this year, your beneficiaries who receive a retirement account, unless they're your spouse or a couple other designated lists, they have 10 years to take out your retirement account. So if you saved over the years and you have a $500,000 or $1 million retirement account, what it means, and let's say you have one child and you designate that child as the beneficiary, that child has 10 years to take all the money out of that retirement account, which means that they cannot spread it out over their lifetime like we used to be able to. So that means their taxable income is going to increase substantially each year that they take distributions. So one technique is to use what we call the Give It Twice plan. And this is a charitable remainder trust in which you place your retirement assets, and it doesn't have to be retirement assets. It could be a home, it could be an investment account, it could be a bank account, it could be any other sort of asset. You can put any assets you want in a charitable remainder trust. You put it in a charitable remainder trust, and in that document, which can be in your will or in your trust, you say, I want my family to receive income from this charitable trust for a term of years. And you can set that term of years as at 5 years up to 20 years, or if you name an individual, you can do their lifetime. So you can say, I want my child to receive a percentage of income every single year from this charitable remainder trust for their entire lifetime. Or maybe you just say it's 15 years. So I've got a number of clients who say, my kids are adults or they'll be adults by the time they inherit, but, I want to help charity and I want to help them. So I'm going to give it twice by naming a charitable remainder trust for my retirement plan. My kids will get distributions of income from that charitable remainder trust for, call it 15 years or 10 years. So they'll get it once, because if you look at the current actuarial rates on charitable remainder trusts, it might be a 6 or 7% payout each year to that beneficiary. And if you look at how much they would get over the 15 years, they're going to receive the full amount. So you've given it once to your family. And then here's where the term remainder comes. Charitable remainder trust says that at the end of that term of years, whatever's left in the account will go to charity. Well, under current investment return conditions, most investment advisors are saying, yeah, we could get 5 to 10% or maybe a 7% rate of return, 6 to 8% rate of return in a charitable remainder trust. That'll pay out every single year to your family. And guess what? The entire balance, the entire corpus that you originally put in there with a reasonable investment return will still be there at the end, and that remainder can go to charity. That has a couple of benefits. Number one is you can stretch out the distributions to your kids over more than 10 years. So it can be for the rest of their lifetime. So number one is you're able to stretch out the tax burden for your kids receiving distributions from that charitable remainder trust. Number two, you're making a high impact gift to charity, because at the end of that 10, 15, or 20 years, whenever the payments end to your family, they'll go to your charity of choice. So it's a powerful device where you can still give to family and you can still provide for charity. So I have been talking for a long time. I hope that what I've shared is helpful, but I hope that you have maybe some questions at this point. And I think, Mira, you're going to field some of those questions.
Yes, so unfortunately, thank you so much, John. What a wealth of information you just provided us all. I really appreciate it. I do have one question, but unfortunately our chat feature doesn't seem to be live here. So what we're going to ask folks to do is, if you have a question at this point, click the participants box at the bottom of your Zoom screen. There's a little box that says participants. If you click that, then an additional box will show and you can raise your hand. And then I will call on you to ask a question. And then that way, hopefully we won't get like multiple people unmuting and trying to ask questions at the same time. But while we're letting folks raise their hand, I do have a question here. At what point do you really suggest that individuals, contract with an attorney to set up an estate plan versus, kind of trying to do it themselves with a DIY, online service or something like that? Is it,
Sure.
Do you have like a dollar amount, an age? What would you recommend?
It's a great question, and some of it is personal preference, of course. Some folks are DIY folks and they want to have it done. I will say, in nearly 100% of the cases, when I have clients who come in who did a LegalZoom will or trust or did a Rocket Lawyer will or trust, it's almost always not signed correctly. So a word of caution that if you do your own documents with LegalZoom or Rocket Lawyer or an online provider, you need to have your documents notarized plus 2 witnesses. So in Oregon, to have a will correctly executed and available to submit to court, you have to have it notarized and witnessed by 2 additional people, which means that if it's you and a spouse, you're going to be sitting there with a notary and 2 other witnesses to sign things correctly. That's usually the missing piece where clients who tried to do it themselves, haven't been successful. What I would say is, if it's feeling cost prohibited to see a professional, because I get it, we're expensive. It's not cheap. Lawyers are terrible, right? I'm the first guy to admit that. I'm a lawyer. Get your documents done. Just do it yourself. It's better to have something than to have nothing. And remember to please work with your financial advisor to coordinate your beneficiary designations on your retirement accounts and your life insurance. So just get it done and coordinate your beneficiary designations. That's my first piece of advice. In terms of when is the right time, if you're thinking to work with a professional, I would recommend as your kids maybe get older, get closer to graduating, as you've built up more substantial assets, if you own property, if your retirement account and your investments accounts are getting larger, that it's a good idea to at least have a conversation with an attorney about whether or not you've got the documents in place that you want. Of course, I'm a little biased. I'd love it if everybody who wanted an estate plan would come see an attorney. I realize that's not practical and that's not the reality of the world. So I just want to encourage people to get your documents done, whether or not it's with me or with another attorney or online.
And my sense is that if you really do take the time to thoughtfully go through the, printed materials and, get your ducks in a row as far as what your wishes are, that can actually help reduce the expense of an attorney, because you've already gone through so much of the process and preparation.
Yeah, that's a great point. And for if you're looking for an attorney to meet with, a couple of resources I have. I am part of a network called Wealth Council, and you can go to estateplanning.com and just type in where you live, and it will provide members of the network that I'm a part of who are in your community where you live and who are near where you live. And for example, I really like only charging flat fees when it comes to estate planning so that clients know when you come in how much you're going to pay. I do a lot of work by the billable hour for business and nonprofit and stuff where I can't really predict how long it's going to take. But the estate planning process is pretty well designed to go for a flat fee. So my recommendation is as you call around, as you email attorneys, as you look for professionals, ask them, do they do it flat fee?
Thank you, John. Okay, I see that James Monroe has his hand up. So James, why don't you go ahead
Hello, Oregon Tech board member James Monroe, ladies and gentlemen.
Hey, so you brought up another quick question, but I actually have a twofold question for you before that. Can you touch on real quick the difference in cost between the probate process real quick and hiring an estate planning attorney? Because I know it's quite different. It's a lot less expensive to do it ahead of time, right?
That's a great point. So in addition to the time, I mentioned that it takes 6 to 12 months to go through a probate process with the court. In Oregon, you have to use an attorney in the probate process. The courts basically require it now. And that, even for a very, very simple estate, is $5,000 to $10,000 of attorney's fees. If it's a more complex estate, it's going to be more than $10,000. That's another reason for my clients, it really isn't any more expensive to set up a revocable trust in advance compared with doing wills. It's almost the same amount of work for us now. It includes a lot of the same information. So you'll maybe do a little more work, maybe spend a little bit more money doing a trust up front, but you're going to save because your family doesn't have to go through court and doesn't necessarily have to hire an attorney to administer the trust on the back end. Although usually I do recommend clients when they've lost a loved one that they at least call and have an initial meeting with an attorney to just get to know the trust administration process. But I've found that it's usually about a quarter of the cost, sometimes much less, of going through a full probate.
And then my question before you brought that one up in my head, you had talked about when to sort of get a trust and when to get that stuff lined up. So take my example. I have a 1 and a 3-year-old. If something happened to my wife and I, we went out to dinner, got in a car accident, died. How does the state, if not pre-set up, deal with the caring of our children and those things?
Yeah, great question. So as part of the estate plan, of course, we would designate who the guardians would be. If you don't designate that or you don't have your documents set up for your kids, then the court, your local court and DHS would make a determination in the best interest of the child of who would be the legal guardian for those children. But when it comes to your assets, this is another piece that's important. The default plan, if you don't have a will or trust set up, is that your kids get access to all your assets at age 18. And most people don't want their 18-year-old to get their full life insurance, their ownership of their house, bank accounts, et cetera, et cetera, et cetera. What they want is to have those assets held in trust or held and managed by somebody else for their kids for a much longer period of time until their kids are more mature.
Great questions. And I see Lee Han Tan has hand raised. So go ahead and ask your question.
My question is, what is the legal age for my kids to be the power attorney or the executor? Is it 18 or 21? Or does it need to be?
That's a great question. The legal age is 18, so your kids can own assets. They can serve as a personal representative, as an executor, or a trustee at age 18. I typically don't recommend that you name a child in that age bracket to be in that role unless they're extremely mature for being an 18-year-old. So I would recommend a couple things. The best, in my opinion, the best possible trustees, if you got that friend who's an accountant who knows your kids really well and you trust them implicitly with your money, that's a great choice. If you have a family friend who's really good with finances, who knows the family, If that is not an option, if you don't have somebody who's in a role like that, you can look to name a professional trustee, whether it's a bank or a trust company, or there are individuals out there who will serve as trustees and executors, and they're usually a little less expensive than having to name a trust company or a bank.
Okay, thank you.
So at this point, there are no additional hands raised that I see. Is there any final question before we close out? James?
One last question real quick, John. At what point should somebody put their trust as the beneficiary for their assets, for their life insurance, for their annuities, for things like that? I come across a lot and have had a few different answers. So in your opinion, at what point should the trust then be named the beneficiary for all that stuff?
Boy, that's such a good question, James, because I'll give you the lawyer answer that we love, which is it depends. A lot of it depends on if it's a first or second marriage situation, because usually I will recommend that the spouse be named as the primary beneficiary still, if it's a married couple, on a retirement account. But sometimes not. Sometimes if you want to provide protections against remarriage, and so a spouse remarried, they could give that account or that money to a new spouse or somebody else and not direct it to the kids when they pass away. If there's a concern about that, clients will name the trust as the primary beneficiary. Life insurance, I almost always like to have that, unless it's a small policy. But if you have a term policy that's $500,000 or $1 million, life insurance is a great asset to flow through the trust for a couple of reasons. Number one is it becomes the easiest, most fungible tool to use to fund what we call the credit shelter, to preserve the deceased spouse's $1 million estate tax exemption, which is a little beyond the scope of what we're talking about today. But so I would leave it at it depends.
Thank you for those excellent questions and answers, John. And thank you so much again for taking the time to be with us during our lunch hour and for your service on the foundation board. You're just a wealth of information, and we truly do appreciate you.
Well, thank you for joining us. I really am just so pleased to see how many people joined this webinar today. I hope it's been informative, and I hope to get to meet some of you.
Wonderful. Thank you all. Have a wonderful day.
Have a great day.